Hi, my name is Arati and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas Co is supporting the program as a knowledge partner. For today's showcase, I'm delighted to introduce you to Sushruti. Sushruti is a recent law graduate and is currently working as a product and legal expert at WebNyai. WebNyai is an online dispute resolution platform specializing in grievance redressal for companies. Most recently, they have been impaneled by the Securities and Exchange Board of India for the new Smart ODR initiative, a project that Sushruti is overlooking. With a solid foundation in law, her focus extends beyond traditional legal boundaries as she navigates the intricate intersection of law and technology. Sushruti always held a strong interest in coding, which translated into an interest in technology law during her academics. She worked on a Chrome extension that scraped Indian Qanun and provided citations at the click of a button, a tool to help law students and practitioners alike. She was also one of the founding members of the Technology Law Society at Jindal University. As a member of the ResEd cohort, an initiative by Resolutio, she researched generative AI and its impact on artists globally. Apart from academic interest, she's a self-proclaimed cinephile and jock. Thank you so much for joining us today, Sushruti. I'm really happy to have you here and look forward to learning more about your presentation on digital rights approaches in India.
Thank you, Arati. So I think we're just gonna jump right into it. I'll just right. So my research paper is titled "A Global Review of Digital Rights," and I've specifically researched in a sort of way to understand what kind of loopholes, what kind of issues could come up for India's Personal Data Protection Act. Going right into it, the aim of my paper is, as policymakers, what insights can we glean from the precedents that have been established in other countries? So the table of contents is going to proceed in this manner. I'm going to go into an introduction first, and then I'm going to talk about the different digital rights that I've discussed in my paper. The third section is sort of combined with the second. We're going to look into the rights, but we're also going to discuss the implementation and enforcement of these rights. And in the fourth part of my discussion is what are the emerging issues. So this is the flow for all three rights as I'm going to discuss them. The countries that I've looked into for research entirely. So since it is a global review, these are not the countries I've limited myself to entirely, but they're the ones that have, showed up most often with respect to cases and, landmark judgments, etc. So that's the United States, the United Kingdom, India, obviously, there's China, and then there's Australia. These nations broadly had a lot of legislation regarding the topic that I was looking into, which is why I specifically highlighted them as the nations that I've analyzed. So there's three rights that I've discussed, and the first is the right to be forgotten. The second is the right to restrict processing with deemed consent, where restrict processing implies a restriction on the processing of data that any principal offers to the data fiduciary. In the act, to sort of simplify it, a data principal is anybody like you and me, a person whose data an organization will have, which then becomes a data fiduciary, and the right to withdraw consent, which is from the processing of such data. So the first in the right to be forgotten, there are three sort of main sub arguments I make. The first is I discussed GDPR and the right to be forgotten, and with Europe, especially with GDPR, they had a well-established, system. They have it written down that the right to be forgotten exists for any citizen of the country. Then I kind of proceed to the global, sorry, kind of proceed to the global spread of the right to be forgotten and how Different nations have seen this come up. And while I'm discussing both of these points, I've brought in a lot of case laws as well. And for Europe, especially, the first right to be forgotten case was that of a German murderer, where a lot of aspects were discussed, whether this information should be public, it should not be public, whether the people have a right to know, so to say, if such kinds of things happen. And I've also discussed concerns of implementation of such a right in India. One second, sorry. So this is sort of encapsulated in section 7 of the act itself, where a data principle, which is us, any citizen, we can ask for erasure of our data from any organization. One of the statistical references that I've made while discussing this section is to Google, and how GDPR grants individuals the right to request de-indexing of personal data from search engines, which originates from the EU's right to be forgotten. But the issue is that Google has received to date. I think pulled up this statistic on in June of 2023. Till then, they had received over 1.4 million requests to remove almost 5.5 million web addresses. Now, the sheer number of this, sort of brings up a question about how this right would be implemented. And in India, it's easier that we have to request the data processor to sort of exercise this right. But what about search engines? And Google has had to represent themselves in a lot of cases as well, where they were constantly asked, in specific disputes, why they made the decision to either de-index the information, or they made the decision to not de-index that information. So my concern with this is, in India also, is how do you manage the appeals that keep coming in from people? And as Indian citizens, obviously we take our rights very seriously. And how are these rights? How is this specific right going to be enforced when the sheer population of the country is so much? It's going to cause a lot of issues going forward. And one of my running arguments in the paper is that although there are a lot of discussions that have happened when the act was being implemented, the multiple iterations of the bills, the Shri Krishna committee recommendations, there's a lot of research that has gone into it. But there's not a lot of information given about how exactly these rights will be enforced later on. So even if they're guaranteed, how do we proceed with that? And this is not a right, that's only discussed in India as of today. Like policymakers from like Argentina, Canada, they're all debating incorporating it into national laws. So what now? And although the 2022 bill introduced a mechanism which allowed erasure of personal data upon withdrawal of consent, that specific clause was removed from the final act. So in section 7, where this act is mentioned, it's also written that the data can be removed by a data processor when a specific purpose is not being served anymore. But there's no definitions of what specific purposes those could be. Um, if a company has my data and they say that they need to have the data for like internal processes, etc., till the end of time, what recourses can I take then? So that's sort of the broader arguments I discuss in the right to be forgotten. These are, sorry, this is the case that I was referring to. The German murderer wins right to be forgotten. Eventually, after an appeal, he was granted the right. Moving on to right to deny consent and deemed consent. Three subtopics I discuss in this again is the Schrems 2 ruling and its impact on cross-Atlantic data transfer, which is a lot of I feel like if anybody who's not from a technology or law background, these words together would be very confusing to them. I also look into global, regional, and local factors that have shaped regulation for different nations, and specifically concerns and challenges in the Indian biometric data regulation. So, just the basics of the Schrems 2 ruling is earlier, US and UK had this sort of agreement where they could transfer data, but then in the Schrems 2 ruling, that framework was sort of revoked. And after that, the United States was basically told by the European Union that you need to have privacy laws that are either exactly the GDPR. So either you follow the GDPR or you draft your own laws, but they have to be as protective as the GDPR. So Schrems 2 was kind of revolutionary in that sense because the United States had to, completely reform their system. And it had a lot of global impact as well, right? Because that judgment itself had so much content on how cross-border data transfer should take place in the first place. And in India, the right to deny consent is specifically mentioned in Section 7. Well, it's not specifically mentioned. Section 7 discusses this aspect called legitimate use, where the deemed consent part of it is not specifically defined, but deemed consent is a situation where any individual essentially agrees to processing of their personal information, and this consent is sort of taken in hand without any explicit consent being provided. So although for some kind of data you need explicit consent from the data principal, for legitimate uses you don't. And one of the examples is employment purposes. So if your workplace asks you to use your fingerprint to log in every day, you have to. And this specific case arose in Australia, where a worker essentially denied his fingerprints to his workplace, and he said that I don't want to provide this. I should be able to say no. And the Australian courts ruled that you know what, you're right. You should be able to deny processing of especially your biometric data. But in India, in this circumstance, what the workplace would be doing would be completely legal and completely within their purview, simply because one, we don't have a definition of sensitive data, sensitive personal data, which are definitions all acts have. Like sensitive data generally, like for example, in the European Union, your sexual orientation would be sensitive personal data, and one of the cases is also where Grindr exported a lot of data tagging people with their sexual orientations. And obviously, when people found out, they were really upset because they did not want this information to be public. Now, if the same case arose in India, we don't have anything called sensitive data, and that issue would then essentially go to court, and an Indian court would decide whether that was legitimate or not legitimate. So if the workplace wala issue came up in India, you will not be able to say no because technically it's legitimate use and it's deemed consent. So my issue here entirely has been about privacy of the Indian citizen and where does that go? Because if you're not able to, if there are certain circumstances where data use is completely legitimate, how do you deny consent? And the Sri Krishna committee in its report has actually discussed this very extensively, and they've said that all data that is to be provided, the consent for it has to be unconditional, and it has to be unequivocal. The principal should say, I understand why my data is being processed and I am okay with my data being processed this way. But that kind of did not play out in the act entirely because legitimate use completely sort of eradicates that opinion of the Sri Krishna committee. This is the Australian case that I was referring to, where after an employee refused to use a fingerprint scanner, they won that landmark privacy case, and the Australian courts did decide that you know what, this was a fair privacy. There was also a case where a Welsh woman won a case uh, along similar lines. She did not want to provide data to her workplace. She argued that she shouldn't be forced to do it, and the courts agreed. But again, in India, there's a statute saying that you have to provide data to your workplace. The third right that I've looked into is the right to information, which on a first glance is not necessarily a right you would, when you think of data protection, this is not one thing that will come up. But the reason I discuss this is due to a very specific clause in the Act itself, which is Section 44(3), which is one of, the last sections actually. And that one replaces the section in the Right to Information Act, where a government official can refuse to provide data if it's personal, if it affects their personal life, sort of a way. Uh, there is no, context given to it. There's no illustrations. There's no explanation. It's just editing the Right to Information Act, and on the face of it, it doesn't seem like an entirely big deal, but when you go into the implementation of an actual right to information in any country, as soon as you sort of set a red tape that it has to qualify this condition for this RTI application to be answered, those are the kinds of things, that later on become bureaucratic and later on cause actual hurdles in the implementation of any like right to information provision in any nation. So I've, used a lot of research papers as well, and I've analyzed exactly what causes a country, a nation to be transparent and, to rank well on indices which discuss RTI laws, etc. And India is actually top rated on quite a lot of these indices, one of them being the UNESCO's right to information rating, where India is in the top 10, Afghanistan ranks first, and surprisingly, most of the Western nations are ranked really, really low. Countries like Philippines, Sierra Leone overtake these countries, and that's simply because developing countries have made more recent laws. Um, Nations like UK, US have had these laws around for a while, so they're a little bit outdated. But my concern is with this very small like change in word, will this mean that there are more RTI applications that end up getting rejected and more hurdles that are caused to right to information later on? And obviously, then again, this also comes in with right to privacy. And there are like a lot of real world scenarios as well. Like for Sierra Leone's Freedom of Information Bill and cases in the Philippines, the Lebanon, there's a lot of complexities where wherever the right to information has been tampered with or edited or amended in any way, shape, or form, uh, it kind of removes the equilibrium between transparency and privacy, and it's caused a lot of privacy concerns in all of these nations. So that's like sort of these are the three subtopics I discussed. So that's sort of my concerns with the right to information as well. Mostly in the entire paper, I've tried to focus on gaps where the act, is not mentioning a specific point, or the act has, missed out on a few considerations while actually being drafted. And even though all of these considerations were made in the previous iterations, like in the bills, they were made in the recommendations made by Sri Krishna Committee. My main hold up was with the fact that they were not implemented in the final act. And then in the end, when these rights are actually like being implemented, being enforced, there's not a lot of clear guidelines for organizations to move towards, and it's going to cause a lot of hurdles when the people start demanding that this right be exercised. And another one of my concerns was also that it's going to lead to a lot more litigation because the act is unclear. So everybody is going to have to question every single thing to get more clarity, and there's going to be a lot of landmark cases, and it's going to be like great for the legislation perspective because everything will then be discussed in the public domain. Everything will be argued by real citizens and real people that get affected by the act. But I do feel like the act itself is a little too bare bones and a lot of recommendations have been ignored. So yeah, that's been my paper. But a really fun fact about this paper is it uses female pronouns instead of male ones, which is the general trend with most litigation legislation in India. So that was a really interesting thing to me when I first went through it.
All right. Thank you so much for that, Sushruti. And I think it's always useful when you're looking at these new laws, like you said, that developing countries are bringing about, to see where the inspiration is coming from and whether that inspiration is sort of being dutifully followed or whether there are deviations in terms of how governments look at it. I think in the Indian case, there was a lot of reference to Singapore, to Australia's data protection laws. And just sort of listening to your presentation was just a really interesting contrast and relief of how policy making and lawmaking works, and where in some cases it struggles to be comprehensive. So thank you a lot for that. I had one question, which was essentially you mentioned at the end that, a law like this, where so much is undefined and sort of left to dedicated legislation, can also lead to a lot of litigation, a lot of legal challenges in the future. And essentially, the courts might end up interpreting the law much more than anything else. And I just wanted to ask, to be the devil's advocate, the data protection law in particular also has an institution like the Data Protection Board of India, which is, of course, government appointed, but whose primary role is to decide on complaints that are related to non-compliance with the law. So if I, as a user, am aggrieved by how someone has refused to say, withdraw my data or erase my data, or if I'm aggrieved by someone not providing the requisite information, I can go to them and ask them to sort of enforce my rights and see how they decide. And even in the case of the Google example that you provided, where you said they get millions of requests to de-index or take down URLs, you also have redressal mechanisms through forums like the IT rules as well to kind of address those complaints. So my question is, when we have these institutions in place, where does the connection with courts becoming overburdened come in? Why do you feel like those institutions, may not be able to handle the burden? Do you actually think that in the first place? And second of all, do you think that they're sufficient to kind of cater to or handle what you call a volume of kind of issues that may come up in the future?
You are like 100% correct in stating that these boards will handle the sort of information that comes in, but sort of requests that come in. But for me, like, it's a pure numbers game, right? You see the population of Europe and you see the kind of numbers they're generating, requests to Google, litigation that's coming up because of that. India's population, is, generally known as more ferocious in terms of protecting their rights. And I am very concerned simply based on the numbers. With such a high number of population, one, secondly, India is, moving to be more tech forward, and we are trying to digitalize as much as possible. I'm concerned that these numbers are going to catch up to us, and this is not something, even the boards of India are going to be able to handle. uh, and especially like even like with my work experience, like you introduced, I've been working on the SEBI ODR system. uh, the sheer number of disputes that are coming in is unexpected, and we're constantly having to rework the system and understand how to do it. And one of the like rules that they implemented was that all disputes have to be sorted out or ironed out in 21 days. uh, Initially that timeline seemed enough, but as these systems are being implemented, there's a lot of concerns that are coming up, and that is solely for the securities market, and that is solely a system for the investors of India. This would be open to everybody 100% completely. That one has a time limitation that it's only applicable on trades that have been made in the past 2 years. This most likely would, like, when it's being implemented, it most likely would not have such a limitation. So, purely speaking, I'm only concerned statistically, and specifically because of the work that I'm doing is the reason this entire, argument came up in my head in the first place. For courts to be overburdened, that's more of, my argument towards why the act doesn't have a lot of definitions, and it doesn't explain a lot of things. Although there are great illustrations for whatever has been illustrated, and it is very explanatory where that happens, just not enough clarity. There could be more that could be provided.
Right. Thank you a lot for that. So I think that answers part of my question, but my larger sort of question, maybe I should have been more articulate, is won't the data protection board flesh out a lot of these issues? Like, do you think it has the capacity or the ability to do that?
Maybe, possibly, could be. In this paper, I've sort of like I tried very hard to limit myself to see all problems that could possibly occur rather than, sort of focusing on problems that could be solved. You are completely 100% right. Yeah, maybe they, do iron everything out, and maybe they do make all of these clarifications, but why not in the act itself? Why not make the act as exhaustive as possible? My Another one of my issues has always been, that law, I think, should be accessible to every person, and especially something like the Data Protection Act is going to be something that's read by a lot of citizens of the nation. Why should they have to refer to multiple sources to understand what the court is trying to say? Why not have it in the in one place as a statutory guide.
Absolutely, that's totally fair. And on a similar line, so a question that we always have as journalists and not legal experts is, okay, it's not in the parent law today, but could it be there in the implementation phase sometime in the future? So you had mentioned issues like sensitive data. We had a different type in previous drafts called critical personal data, which was like ultra sensitive. So do you see categories like that? Is it legally permissible to introduce categories like that and different kinds of protection for them in subsequent rules that will be issued under the law? Or is that just not going to be a reality in the future?
Based on the previous bills, I do think it might be included later on, and it is very reasonably possible that the Indian government wanted to wait and see how it's fleshed out, sort of hold more discussions and figure out what categories should be sensitive data, what categories shouldn't, because over the iterations also those definitions did change. I do think it's permissible. I don't think it's impermissible at all. I 100% fully don't understand the reason why it wasn't incorporated in the act already, but I do see it as a possibility in the future. I do feel like it's critical enough for it to be, sort of written down within the act so that it's a set guideline for all the organizations coming forward.
Right, understood. And yeah, just my final question over here, and this is really on the question of deemed consent, which has kind of flipped the traditional idea of providing consent on its head. So the final question that I had is, we know that deemed consent essentially allows a data processor to process data without gaining someone's explicit approval for it. But does that mean, as per your reading of the act or of the law, that the person doesn't need to be notified? So you might be taking my information and processing it, but does the law mandate that even in that case, I'm entitled to a notice, I'm entitled to understanding what the purpose of processing is and why any other sort of extraneous information? So, as per your understanding, is that required under the law in the case of deemed consent, providing notice?
Uh, yeah. For sure, a data principal has to be provided notice of what data is being processed, for what purposes that data is being processed. And as per my understanding, a data principal can also say no. In turn, they won't avail the services that the organization is offering or whatever company that they've signed up to. I think at that point, that sort of transfer of goods and services and information can be stopped. But yeah, they do have to notify. I think it's covered under Section 5 of the Act, if I'm not wrong.
All right, great. Thank you so much for this, Sushruti. This has been a really illuminating discussion, and thank you for bringing so much of your perspective as well to the table. If you'd like to learn more about Sushruti's work or any of the other scholars, you can visit MediaNama's website or YouTube channel for more on the presentations and our articles on them. And if you'd also like to read more about India's data protection law and its applications, you can find that on the website as well. Thank you so much, Sushruti.
Thank you, Aarti.